That leads right into, let's talk about the will and the trust, because if you haven't set up a will since maybe your children were young and you were just trying to figure out who maybe would take care of them if you pass, that sure changes as you're heading to and through retirement. So let's talk about how the will, it could be used in that stage of life, Charlie, and the trust.
Well, sure, especially if you've done a will when you have small children and you've moved on past that phase, chances are that document's not going to meet your needs because your needs are different. I mean, a will is basically a legal memorandum instructing the court, instructing the fiduciary, your executor, the judge, to send your assets where the will says you're going to send your assets. But it doesn't do anything to help you avoid probate. It doesn't do anything, to deal with any other special circumstances that might have come up in the last 25, 30, current record is 60 years. It's a very oftentimes basic document. They can get a little more complex if you have a little bit more complex of a will with maybe a trust built into it. But, in their basic function, they are just instructions for the court to move your assets from point A to point B, which is often misunderstood as also helping you avoid probate, which a will does not.
Okay, so a lot of people then do maybe consider a trust. And again, I also feel like a trust feels like something for the ultra wealthy, but I've heard you talk about this before, Charlie. I mean, if you have a car and a home, you're already kind of bumped up into that net worth of maybe needing a trust.
Yeah, a lot of people don't recognize or understand that IRA uses a concept called your gross taxable estate. It's an IRS term. Basically what it means is if you had access to those dollars, we'll call it 3 seconds before you passed away, and any life insurance beneficiary, death benefit that you have, and any taxable or non-taxable gifts you made in the last 3 years, those are all rolled into your gross taxable estate. So it's really common for people to say, oh, well, I have an IRA or a 401k at work, and I have, my kids as the beneficiary on that. That doesn't go through probate. That's true. It doesn't go through probate for routing purposes, but it still ends up on your estate inventory, and most of the costs and the fees that are associated with probate are based on your gross taxable estate. The one asset we get to exclude from anything probate related, and it still goes on the inventory, is life insurance with a direct beneficiary. But even that I find to be misunderstood, because if I have life insurance and it pays to my wife and I pass away and she passes away 45 days later, that's cash. She received that cash and is now part of the estate. So a properly drafted and funded trust is the most efficient, I'm going to say best way to avoid probate in our state, especially if you own a home, especially if you have assets that are, worth more than $500,000-$600,000. A lot of people don't recognize that probate can be $15,000-$20,000. A trust is a heck of a lot cheaper than that.
Let's talk a little bit about the different kinds of trusts. I think I've read a little bit about revocable living trust and irrevocable trust. What's the difference and advantages and disadvantages?
Sure. I mean, you have the obvious. One is irrevocable, which means you can't revoke it, which is actually not true. It just means it's hard. But
no, it's not true.
Typically speaking, the way I describe the differences is we use irrevocable trusts for very, very specific purposes, right? So if we're doing, some Medicaid's asset protection, we would use a specific irrevocable trust for that. If we're using we're trying to do some estate tax mitigation, which we'll get into further, and we're using life insurance to help pay down some of those estate tax bills. We're doing something called an ILIT, an irrevocable life insurance trust. A revocable trust, on the other hand, is just your, I'm not going to call it run-of-the-mill because they're not run-of-the-mill, but it's your utility plan. It's there. It's a will substitute. It's designed to get your assets from point A, that's you, to point B, whether that's your spouse, whether it's your children, some other beneficiary. I deal with people all the time who don't have kids. They have stuff too. They have needs too, right? So it's designed to get those assets from point A to point B. The key is, if all of your assets are in a trust or have a direct beneficiary, we don't need to open probate to move your assets from point A to point B. If we don't need to open probate to move your assets to point A to point B, we don't need a judge. If we don't need a judge, we don't need probate. If we don't need probate, all those fees don't apply. So the key, and I'm going to throw it back to Loren on this one, the key is, and this is why the team is so important, your financial advisor, your banker, your CPA have to also understand what you're doing, because if your financial advisor doesn't understand what you're doing on an estate plan side, your beneficiaries are going to be wrong, not necessarily, but they could be wrong. And if those beneficiaries are wrong, that might trigger probate, which defeats the entire purpose of comprehensive estate.
Yeah, a lot of times when people come to us for the first time, we talk about a legacy plan. Maybe they've worked with an attorney to create an effective legacy plan, but then I'll dive deeper into the question. I'll say, okay, you have a revocable trust. I don't see it anywhere on your accounts. How are you actually using this revocable trust? And many times they'll come back and say, I don't know. I got this list of instructions from my attorney. I don't know how to interpret it. I haven't got a lot of assistance from my attorney as far as how to use this after it's been created. And then we have to dive further into how are you going to actually use this? And so a phone call to the attorney, looping in the client typically is a good way to go, which is why I appreciate working with you, because it is pretty clear what they should be doing afterwards. And you're just a phone call away, and we're both on the same page when it comes time to it. The revocable trust is the most common type of trust that you do work with. One of the misconceptions of the revocable trust, a lot of people think that having assets in the trust will help them protect against Medicaid. But in fact, that's not the case. So in that particular instance, if somebody's looking for that Medicaid protection, what are they doing?
We would need an irrevocable trust. And you need to understand, you talk to a Medicaid specialist, because there's a lot of rules. And when you send assets to an irrevocable trust for a Medicaid purpose, there's going to be a look back period where you're not eligible for Medicaid. And that look back period is directly correlated to how large of a gift you are making to that trust. Basically, you take that gift, you divide it by the Iowa average for medical assistance, but then you take that, and that's how many months you are ineligible, with a maximum of 60. So it's important to do that in a plan and not just sort of ad hoc, because I have seen situations where people have transferred assets and then they've waited, and then they've transferred some more assets. Well, you're just restarting that clock.